Forward for our next case, which is Calvert versus Ellickson, case number 24-872. Sir. Are we set to move forward?
Yes, Your Honor.
All right. Again, we're here on case number 24-872, Calvert versus Ellickson. Counsel for the appellant may proceed.
May it please the court, Austin Calhoun on behalf of appellant Mr. Spencer Calvert, and I'd like to reserve 5 minutes for rebuttal.
Thank you, Mr. Calhoun. You may proceed.
Thank you, Your Honor. I'm here to reiterate just a few things that have already been briefed. First, the trial court may have been misled by some things outside of the complaint and should have stuck to what was alleged in the complaint. Second, this is not a case of whether an agreement exists or not. The agreement clearly exists and it was signed. Instead, this is a case about scope or arbitrability. And then the first prong is who gets to decide that, the arbitrator or the court?
Let me start where you started, Mr. Calhoun. You mentioned complaint. We're here related to a ruling on the appellee's complaint, not the amended complaint, correct?
Correct, Your Honor.
And currently in the trial court in St. Johns County, there is an amended complaint, correct?
Correct.
And that amended complaint is not in front of us.
Correct.
So, given that and understanding what the rules of procedure tell us that an amended complaint supersedes a complaint, why is this case not moot here today? Because what we have is a predecessor complaint that it was superseded by an amended complaint. So why is this current appeal not moot?
It's a great question, Your Honor. That has not been argued by appellee, and I'm not fully prepared to answer that question.
No, thank you, and thank you, Mr. Calhoun. Candor is appreciated with the court. And this particular judge, I can't speak for my colleagues, I don't have a problem with some supplemental briefing maybe on that issue. Why don't we do this? Related to the mootness question, from today, we will give you 10 days to, at the same time, submit supplemental briefing. That's not a rebuttal of the other brief. That's both of you presenting at the same time. And the question, as you heard me verbalize, is we know the rules of procedure say that when there is an amended complaint and the cases are legion, that amended complaint completely supersedes the predecessor complaint. And you did a nice job, Mr. Calhoun, in your reply brief of saying we're only here about the complaint. And I think you're right about that. This amended complaint, it was not in front of the court. The court never ruled on the amended complaint. So the question, again, for the presiding judge today and hopefully for the panel would be why this appeal is not moot based on the presence of the amended complaint, the active complaint, currently pending in St. Johns County. And as you're briefing this, and this is, I did a little bit of a jet tour last night through some cases. There is a recent case, an Amendment 4 case out of the First District Court of Appeal. You may remember it dealt with a financial impact statement. And there was a financial impact statement related to Amendment 4. It was appealed to the First District. And then during the appeal, that financial impact statement was amended. And the First District, I believe it was Judge Ray, Bilbrey, and Kelsey, said that because it had been amended, that the appeal related to the initial financial impact statement was moot. There's also a case, I think 2011, again out of the First DCA, with Judges Marsteller, Ray, and Weatherall. The way you would find it is it's Wilner-Hartley, 2011. But here's the point of that case. There was a second amended complaint. There was a motion to transfer venue of the second amended complaint. And while the motion to transfer venue related to the second amended complaint was denied, and while that was pending, and or before it was pending, there was a third amended complaint. And the First District in that case said that the third amended complaint superseded the second amended complaint, so what was in front of the first was moot. I just point those cases out to you. They may or may not apply to our analysis here, but it just struck me where we know that we have a superseding event. Is it really something for us to determine? And you know that's important. Thank you all. If you could please try to keep your seats, that would be appreciated. If you have to leave, that's fine. But if we were to look at this as something that is judiciable, something that is for us to determine, it seems, again, to this judge, that there's nothing for us to determine here if this complaint that is the very basis of this appeal is not currently the active complaint.
Okay.
So all that aside, Mr. Callahan, you mentioned an agreement. As to the substance of this case, where does it say that Mr. Calvert in that agreement is entitled to arbitration?
One more thing, Your Honor, just
Sure.
on the mootness issue.
Yes.
We filed a notice of related cases. In case the panel wasn't aware, there are numerous cases that are very similar to this one that are pending in St. Johns County right now.
And I saw, and I believe it was an appendix to the answer brief, there was an order related to the Surrency case that did deal with the amended complaint. And I believe that was Judge Maltz, where he dealt with a subsequent complaint, which is a completely different paradigm. And I don't know this, I haven't studied that complaint, but that may have some more specificity than the initial complaint in Surrency. But that's not our case. And that I saw, am I correct, there has been no ruling as to whether the amended complaint could be subject to arbitration or not in this case?
In this case, no ruling on the amended complaint.
All right.
But on the others, those have been similarly denied.
And I understand that. And I think in Surrency it was denied. But that's a different fact pattern than we have, Mr. Calhoun. So back to the agreement. In the agreement, I didn't see your client mentioned as a party to the agreement. Am I correct about that?
Without a doubt, Mr. Calvert is not a party per se to the agreement. We are seeking to enforce as a non-party. While not being a party, his contractor's license number is identified at the top of page 1. And I'll point out that the contract does not contain a no third-party beneficiary provision.
Is that something that's common? I don't know if I've ever seen a no third-party beneficiary clause.
Yeah, I see it quite often. I wouldn't say that it's in a majority or not a majority of contracts, but it's a thing.
Okay. Good. The case law I looked at said that typically third parties don't have any rights on an arbitration agreement if they're not named. So maybe that kind of clause came about to reinforce the existing law, which is to say you don't have any rights.
I don't believe the genesis of that provision was pertaining to arbitration, but more fundamental concepts in contracts.
Fair enough.
I've got the builder contract agreement. I didn't word search it, Mr. Calvin. Is your client mentioned by name in the builder contract agreement?
His name is on the signature block as agent for Pineapple, the contracting.
But in the substance of the agreement, his name does not appear.
Not that I'm aware of. It's a pretty lengthy contract. Maybe it's buried in there somewhere, but that's not our argument. Our argument isn't that he's a party.
And your argument is that he's a third-party beneficiary. And back to what I believe, I don't want to speak for Judge Makar, but Judge Makar's potential point. Does it say in this builder contract agreement that third parties are going to be protected by this agreement?
No, it doesn't. And again, so our argument isn't third-party beneficiary per se either. It is equitable estoppel as agent or officer. And that's the second prong of our argument. Our first prong is the trial court should not be answering that arbitrability question. That should be the arbitrator answering that question.
Maybe you took that to its logical end. Someone who's not referenced in an agreement could then have a third-party arbitrator make a determination that they are in the agreement. I mean, you took it to its logical end. Couldn't that create chaos? Potentially.
So the starting point is we're enforcing the agreement against a signatory. These plaintiffs signed the contract. They allege the contract in the complaint. They incorporate this contract in every cause of action against Mr. Calvert. So we're not pulling the contract out of thin air here. They made it part of the case, they being the plaintiffs. And they certainly were aware of Mr. Calvert and his involvement in the project. And like I said, his license number is identified on the top of page 1. So he's not a stranger to the project, to the contract. And there is case law that says, through equitable estoppel or otherwise, that non-parties can enforce arbitration provisions against a party that signed that contract.
What do you do? I've got the binding arbitration provision, and you know it well, I'm sure, Mr. Calhoun. All controversies and claims between the owner and contractor, directly or indirectly, should be rising out of or relating to this contract or this transaction. Doesn't mention your client there, does it?
It does not state my client's name in the arbitration provision.
So you're asking us through equity to impose something on an agreement that's not in the agreement. Is that not the position, Mr. Calvin?
It is an agreement that the plaintiffs have entered into. The issue is, does the claims they brought, incorporating this contract, do they fit within the scope of the arbitration provision? Do the claims they bring, are they direct or indirect from that contract?
Well, and Mr. Calvin, I get it as to Pineapple, the construction company. And I was fortunate to have authored the Zion Jacksonville case, which you referenced a couple of times. And that was a reincorporation by reference of the agreement in every single count and a discussion of the behavior in that contract in every single count. But the difference there, it would seem to this judge, is those were signatories to that arbitration agreement. Your client is not a signatory to this agreement in the sense that he's not a party referenced in the agreement itself, correct?
Correct. Yeah. I'm relying on case law, the equitable estoppel case law, that says non-parties, non-signatories can enforce. In this case, an agent can enforce a contract entered into by its principal. They've alleged that Mr. Calvert is the agent of Pineapple. In fact, the qualifying agent of Pineapple. It's Pineapple's contract, Pineapple's the principal. Agent can enforce it. And there is case law, and we've cited that in our briefing. And the analysis for this arbitrability issue is that the causes of action must be interdependent or intertwined with the contract, with the principal. And that's exactly what we have here.
What do you do with their argument, and they make it repeatedly, that the principally offended party here is Pineapple, not the underlying plaintiffs, meaning there is not an interrelation, it's just the opposite. There's a conflict between Mr. Calvert and Pineapple. What do you do with that argument?
It's not in the complaint. That's not their cause of action. I mean, I could go further, but I think we need to stop there. I think we're constrained to looking at what they've alleged. This is a little bit out of turn because we're not to the amended complaint yet, but even there, they're not bringing causes of action derivatively through Pineapple.
But the assertion, and you would say it only appears in the amended complaint, but the assertion is that Mr. Calvert did something related to Pineapple that he shouldn't have done. Is what the plaintiffs are claiming, right?
That's not alleged in the complaint. That what they've alleged is it starts at a run-of-the-mill construction project dispute. They paid money, contractor ran out of money, couldn't build on time and on budget, asked them for a change order, they refused, and contractor couldn't finish. Then they take it a step further and say, well, why'd contractor run out of money? And they disregard this extreme market condition we all just experienced post-COVID where all the prices skyrocketed. And instead of that, they go straight to, well, this guy must have stole the money from Pineapple. Right? But that would be a Pineapple cause of action, if it existed. But, what they really have is a breach of contract against Pineapple.
Well, Mr. Calhoun, you're into your rebuttal time. You're welcome to proceed or reserve the rest of your time.
I should reserve. Thank you.
Thank you, Mr. Calhoun. Please proceed. Mr. Hughes?
Good afternoon, Your Honors. Brad Hughes and Brittany Mills here on behalf of the Alexsons. Mr. Alexson is in the audience here today, as well as other victims of the criminal charges that have been brought against Mr. Calvert. So what I wanted to do first, Your Honor, is address this mootness matter. And I would just say it doesn't matter. I don't think this is an issue that's moot. And one of the main reasons is this isn't jurisdictional. This isn't like the case is over. This is an interlocutory appeal. And I understand that some of the allegations, and there's some additional allegations in the amended complaint, but that's the way things work in these kinds of cases. I mean, you know what you know until you get discovery.
Which I fully understand. But you agree with the court that what the law tells us is when you have an amended complaint, the complaint evaporates. I mean, it is no longer a part of the case anymore. You would agree with that, would you not?
The First Amendment, yes, Your Honor. And so I would say that if this court were to send it back to have this resolved again, we'd have to amend yet again, because on July 9th of 2024, the certified fraud examiner issued his report and identified like $2 million of direct payments from the Pineapple account directly to Calvert's personal bank account. And then at that point, do I have to file a motion for leave to amend? But there's a motion to stay pending arbitration. Do we then have to arbitrate the one, come back here for the one complaint that's still pending and then go back so I can amend. I mean, my point is things don't get better for Mr. Calvert through amendment. They get worse, much, much worse. And I would like to walk through the allegations in the complaint.
Certainly, but I'm just trying to understand, assuming the complaint which is in front of us no longer exists by virtue of the filing of the amended complaint, and that was a lawful filing, correct?
It was a lawful filing.
And under 1190, as a matter of right, your client has one chance, at least, as a matter of right, to file an amended complaint, correct?
That is correct, Your Honor.
Yeah, so there's no question in this case that the amended complaint, it was lawfully filed by your clients.
That is accurate. And I understand, Your Honor. I would say that, I think that the mootness issue, the potential mootness issue may be procedure over substance. And what I mean by that is I understand you're saying the complaint evaporated, but it didn't, because those allegations in the complaint are still there. It's not like those allegations went away. Those allegations are just incorporated into additional allegations.
And I hear you, but that complaint is no longer in front of the circuit court, the initial complaint, correct?
The amended complaint is, the action is, and so as I said, I don't think this is a jurisdictional issue. I think Your Honor can take note of the fact that the amended complaint incorporates those allegations from the original complaint.
But how, I mean, I'm concerned about due process for the appellant, but I'm also concerned that you're asking, or at least the appellant's asking, that we reverse the trial court. The trial court has not ruled on the amended complaint in this case, as to its, whether it was an arbitratable, something that was arbitrable controversy, correct?
That's correct, Your Honor. But if y'all, and perhaps if y'all were inclined to reverse, there should be opportunity for that to be heard by the court. But if you're not inclined to reverse and you're simply going to affirm, I mean, the allegations in the initial complaint are there in the amended complaint. And so I don't see the harm in ruling upon, the court's ruling, because things are not going to, like I said, get better for Mr. Calvert based upon these additional allegations.
And we understand a lot was put into all of this, but help me understand, help our panel understand, the amended complaint is not in front of us. The amended complaint has not been ruled on as to a motion that the claims in the amended complaint should be subject to arbitration. So how in the world can we deal with that related to this case that currently stands in front of us?
But I would say the amended complaint's not before you. I mean, the amended complaint is filed with the court. It's a lawful filing. The court has not ruled, the trial court has not ruled upon the amended complaint. But the trial court did rule upon, the specific allegations in the original complaint, said that's enough. And I think Your Honors can take that and say, was there enough asserted in the complaint? If there was, then we'll affirm, and the case can move forward.
Isn't that an advisory opinion, though? I mean, the amended complaint has not been ruled upon. That would be a justiciable issue for the court. I just don't see how we can deal with something that has been superseded.
Yeah.
But help me, maybe I'm missing something.
Yeah, I mean, I don't think it would be an advisory opinion, Your Honor. I think it does get back to jurisdictional versus not. I mean, these are interlocutory issues, and so the complaint itself alleges specifically that Calvert intentionally diverted proceeds in paragraph 14. And the original complaint says that Calvert admitted that he used funds for Alexson's upgrades for different projects. The original complaint says about $130,000 in liens for work that was not performed. And that's a crime under 713.345, which we know Calvert's been charged with. The original complaint says that Calvert converted these funds. Like you said, it's an offense upon Pineapple. And I think Pineapple does have claims against Calvert. And such, in stealing from Pineapple, they stole from my clients. And then paragraph 39, again, in the context of Reducta, says that Calvert misappropriated the construction funds. So, I mean, all of these things taken into consideration, Your Honor, and I know that you appreciate the procedural, position that we're in if this gets sent back to court, is now I've got, under 1.190, I've got a complaint that's partially amended, but really needs to be amended to include fraudulent transfers, lots of them.
Well, help
Yeah.
us as a panel think through it. Hypothetically, if we were to find this appeal moot, send the case back, is there something more we could do in saying that?
I think if your honors were to do that, you could have some instructions, remand with instructions to the court, and cite Florida Roads Trucking and things of that nature. So, I think certainly if the court was inclined to remand, there could be instructions that, the court's not to deviate from its initial ruling, the trial court's not to deviate from its initial ruling, on Coachley, and they didn't have the. Yeah.
And I appreciate the position. You're giving me an advocacy position, but we're going to tell the trial court that he can't change his mind related to the amended complaint. I mean, you're not suggesting that, are you?
I think the court can suggest, to the trial court what they think, the ruling was based upon the allegations in the complaint. And in all candor, I don't think that the court's going to change their mind. Like I said, things don't get better for Mr. Calvert on these allegations.
Well, isn't your point? I think you'd say it's not. Let's just concede it's moot, but that doesn't mean it's over, because in Florida, under our jurisprudence, it's discretionary whether we move forward on a moot case, because sometimes there's exceptions to mootness, important questions or whatnot. It sounds to me like perhaps, and I'm just thinking out loud here because it's a new issue for y'all to be thinking about, but if the state of the law is that third parties can't assert the benefits of an arbitration agreement, that's the same law today as it would be against the amended complaint. So perhaps positions that say, well, yes, it is technically moot, but because we have the same sort of party alignment, Pineapple's not a part of this, right?
Pineapple's different lawsuits against Pineapple.
Right, not in this case.
That's correct.
This is just against Mr. Calvert because of his alleged misappropriation of funds.
Yes, Your Honor.
So I think maybe what you're trying to convey is the sun's going to rise. In this case, it's going to rise tomorrow. It's the same situation, same parties. If there's no ability to arbitrate, let's find out here and now, so the trial judge has the benefit of that.
Yeah, that's exactly.
But it's moot.
That's exactly what I'm saying, Your Honor. Is if it is, I guess, deemed moot and remanded for mootness, the court can exercise their discretion. We can certainly brief these issues.
Could you withdraw your amended complaint in that circumstance? If we rule for it in your favor, could you go back to the trial court and say, well, we don't need to?
I thought about this. In the Coachley case, right? The concern is that allegations determine whether you arbitrate, right? So, complaint number one, you don't get it right, and the court compels arbitration and say, never mind, I'll dismiss my case, I'll refile it, make new allegations, and then those allegations themselves will have to go back before the court, again. So, I could, I guess, withdraw my amended complaint, understanding that as I'm talking to you, I would think I would still get another bite at that apple, for lack of a better term, if the court were to decline that, were to reverse. But the Coachley State case does reference allegations, which to me is a little odd as opposed to the truth.
The amended complaint's not being held in abeyance. Is the amended complaint being held in abeyance?
The amended complaint is not being held in abeyance. As I've informed Your Honors, we do need to amend again to include these $2 million of fraudulent transfers or so that were specifically identified by the certified fraud examiner. I think that's really where we really get into some difficult procedural things, because I don't know if the court would be able to grant that amendment, while the motion to compel arbitration is pending. So that's what I'm saying. I think this might be procedure over substance, because ultimately, if it's moot and it's remanded back for mootness, we'll have to amend again, and that second amended complaint is not going to, be operative, I guess, for lack of a better term, at the time that we get here again.
Help us understand how did this all happen? We've got the initial ruling on the complaint. We have the notice of appeal, and then after the notice of appeal, we see the filing of the amended complaint. And as again, this judge understands the rule, that was perfectly acceptable to do under 1190A. Is that how it happened?
So we have a lot of things going on. So
Okay.
you have a complaint that's filed like in January, I think. The arrest happens February 22nd. The hearing happens just 2 weeks after the arrest. And so in the arrest, we get, to the arrest and booking report, but that's all. Then I think it was April the 11th, the hearing was on March 11th. Then the amended complaint came shortly thereafter. The day after the amended complaint was filed was when the Zion case was entered. So then the Zion case gets entered. So admittedly, the trial court didn't have the benefit of Zion. And then, once that happens, July 9th, 2024 is when they actually charge him. And then at that point, you can start trying to get information, I guess, from the state attorney's office. But, at any of these misappropriation cases, I mean, the defense 101 is motion dismiss, we're not going to produce any documents, you can't see where the money went. And so you can see the frustration of the Alexsons and the other victims, with this, concept that we need to remand so that they can, again, not produce their documents. Again, we can fight with the state attorney's office to get more information when it's really clear, what's happening here, or at least what the state thinks has happened here. So, I think those, and I hope that answered your question, Judge Shea. I think that was kind of the order of operations and how things got to where they were.
Which accentuates Judge Mekar's question. None of this was held in advance because the request to stay this proceeding was denied.
Well, no, the motion to compel arbitration was denied.
Was there a motion to stay?
There was a motion to stay. That was granted provisionally. Judge Janesk is giving case management conferences to update. He said he's not going to stay indefinitely, and so.
But that was after the appeal.
That was after the notice of appeal.
And after the amended complaint.
And after the amended complaint, yes.
So he didn't stay it before you filed the amended complaint. I guess that's my point, and I didn't ask it very well.
He did not stay it before the amended complaint was entered. And I mean, frankly, when you look at the arbitration clause, our argument not to stay is the arbitration clause specifically says that discovery will be conducted under the Florida Rules of Civil Procedure. And so he said, no harm, no foul, let us do our discovery, and so maybe, Judge Makar, there could be, in a remand or something of that nature, something about, that y'all don't consider the case stayed or that you wouldn't have any objection to the case moving forward for discovery, if there was a remand, just because y'all understand the procedural quagmire that we'll be in if it's remanded at this point. Meanwhile, defendant who doesn't want to answer questions and potentially plead the fifth, I mean, that's A-okay for him. So, I mean, I don't know if y'all had any other questions about mootness or kind of how things would move forward, but I mean, the rest of this, I think y'all hit on, in your argument, and I thought it was pretty clear that contract language matters, and that's what the cases say. And y'all read directly from the arbitration provision, and he's not, a signatory, he's not named himself personally in any of these things. I mean, we do think this falls directly within the Florida Roads trucking, matter, not under equitable estoppel.
And that does distinguish this case, based on your position, from the Zion Jacksonville case, where they were signatories parties to the agreement, correct?
Yes, Your Honor.
But the trucking case, Judge Pratt's opinion, was different because that was a group of third parties that were not signatories to the agreement.
Exactly correct.
So that's how you would differentiate between two very recent opinions from our court.
Very recent opinions. I mean, you didn't use the language or the pun from Coakley about excavating and filling the contract with new terms, but I mean, that's exactly what you're saying is you can't excavate this contract and fill it with new terms that makes Calvert a party, which I think is how the Coachley case ended.
Well, and there was I correct? There's no mention of Mr. Calvert in this agreement, in the body of this agreement?
There's no mention. The only mention of anything related to Calvert at all would be the license number, but that's not, it doesn't mention him by name or anything of that nature.
And is it undisputed from your position that he was not the owner and he was not the contractor as defined in the agreement?
Correct. Yeah, just like in Coachley, Calvert is not the Alexsons. Calvert is not Pineapple. And so therefore Calvert can't enforce the agreement.
So the owners, Alexson's, your client, the contractor, Pineapple,
Right.
not Calvin.
Correct. Yeah, and you know, just one more thought, and I'll walk back into the smoothness as I Dora, that as I kind of finish up here is the notice of related cases that they file identify all these cases. I mean, you're right, Your Honor. Some of the cases do rule on the amended complaint, which has the same amended language, and then they state in their notice of related cases that there's no difference amongst any of these matters. I don't know if Mr. Calhoun and his client wishes to appeal before the bench 5 different times, because there's 7 different times, I guess, with 7 different parties. But I think that whatever Your Honors were to rule here would be the same on all the cases. The only difference in any of these cases is that one of them, the Krebs case, which was the most recent one, that was a stole all the money case, where there was $450,000 that was deposited and nothing was done, not even a permit. And these are just stole most of the money cases. Unless y'all had any other questions or anything for me, Your Honors.
No further questions.
Thank you.
Thank you. Mr. Calhoun?
Thank you, Your Honor. So, in rebuttal, I'd like to distinguish the Florida Roads Trucking versus Zion case, which we've been talking about, and just make sure that was clear. That was a case about a subcontractor to a general contractor. That is not what we have here.
But in the point of Florida Roads Trucking, that those trucking entities were not part of the agreement. Isn't that sort of the point of that decision? And if you're not part of the agreement, it's got to be something pretty extraordinary to claim entitlement to arbitrate. I mean, and maybe that's an oversimplification, Mr. Calhoun, but that's the way I understand Judge Pratt's opinion.
Likewise, and he says, this case does not fit the description of where the non-signatory defendant is an officer or agent of a signatory. That is this case. They've sued Mr. Calvert as officer and agent of the signatory. So, Judge Pratt and Zion doesn't say, had they been an officer or an agent, then they would have come to a different conclusion, but it implies that. And so we're somewhere, where we're at is somewhere in between those two cases Your Honor mentioned a few minutes ago. On one end of the spectrum, it's a signatory. The other end of the spectrum, it's a non-signatory who's a subcontractor, not really related to the signatory contractor. Here we're the agent and officer of the signatory. And they are suing us as agent. This isn't a case where it's, sure, he's the agent of Pineapple, but he did something else over here. They actually allege he is the agent. We're suing him as agent and the things he did as agent. And the case is, they sued Pineapple concurrently with Mr. Calvert here. Why they separated the two, I don't know, because they're identical and they're seeking the same exact relief. They can't get both. Are they trying to get 2 judgments? It's the same dollars, same money they're seeking. They paid X money to Pineapple. They want some of that money back. Are they getting it from a judgment from Calvert or Pineapple? It's the same money. And to determine how much money they get back, you have to interpret this contract. There's no way to determine any judgment. Let's, for sake of argument, let's say they went on conversion against Mr. Calvert. What damages amount? Well, you have to interpret the contract. They paid money to Pineapple. How much work did Pineapple do? There's a lot of contract provisions that talk about then what they would be owed back, if anything. And you got to do that contract analysis before you can arrive at damages against Mr. Calvert. And if there's any on the question of, well, the contract language says what it says. Well, if there's any ambiguity about it, tie goes to Mr. Calvert. Florida cases, Florida has a preference to send cases to arbitration And I think the case law says if there's any ambiguity, it must be resolved in favor of sending the case to arbitration. And my time is up.
Thank you, Mr. Calhoun. Thank you both. It was well presented on both sides. We are, as a court, officially in recess, so the lawyers are welcome to leave. We